If you haven't heard about Levelset, we know the construction industry is a confusing place, so we try to offer solutions to kind of take away the headaches. We have software that handles liens and waivers. We do contractor profiles and risk management reports. We have online payments. And then we also have the community, which is what I am managing, where we get credit managers and credit professionals together to kind of share their education and experience and mentor and keep learning and stuff like that. Today we have Tom's, I'm probably going to say it wrong, Scalisi with us. He is actually an author for Levelset, and saw this topic that he had wrote about and thought it would be a great thing for everybody to listen to. Tom, do you mind introducing yourself a little bit?
Sure, no problem. You said my name right. It's Tom Scalisi. So I am a writer. I'm not a presenter or a webinar host, so I hope everybody kind of bears with me here. But I was a contractor for years. I kind of grew up wanting to be that guy on the job site working by himself, like the peace and quiet of the job site. So I got into renovations. I did that for several years and always experienced the issue that everybody has with cash flow. And I had a young family at the time. So for me, trying to track down my cash, trying to get paid for jobs that I had, credit out on, became very difficult. So I decided to get out of contracting. Now I write a lot of home improvement and construction stuff. And I had the opportunity a little more than a year ago, to partner with Levelset. And in doing so, I get the opportunity to kind of educate contractors on what they can do to avoid the things that I was dealing with. So, very happy to be partnered with the team. And now I can write instead of bang nails, and I appreciate that.
We are very glad to have you today. So thank you for joining us.
Thank you.
Today, we're going to cover understanding what happens when a lien is filed. We'll learn when liens expire and the requirements and deadlines, through different states for that. We'll learn how to extend a lien in some states, protect yourself from the property owner shortening the lien window. This is something I had never heard about, so I can't wait for that part. And then we're also going to talk about reducing the risk of having to release the lien without payment.
So everybody knows when a bank holds a mortgage lien, that lien is going to last for as long as the money is owed on the property. When it comes to the tax lien and the government, and you owe the government money, they are not going to release that lien until they get paid. Obviously, we know that's how the government works. And liens on vehicles can they can outlast the vehicle. It's the way vehicles are made today. You can pay for a vehicle for 10 years and it won't even make it that long. But that's completely different than with a mechanics lien. Mechanics liens last, and they actually expire. Unlike those liens, a mechanics lien will expire. It's usually sometimes between like 90 days and a year, but every state has its own rules as to how long before the lien actually expires. The takeaway is that they do expire. They're not like the mortgage or the tax lien or even the vehicle lien. They do expire. After they do, the lien is no longer valid and it has to be removed. So if they expire, can a project owner wait them out? So the question is, if a mechanics lien can expire and turn to dust, it's not very effective. All a project owner would have to do is wait them out. It would seem like they could hang back, let the contractor sweat, and if nothing else happens, they're scot-free. In theory, they could try that approach, but a contractor who's determined to recover their cash is not going to let that happen. In order to take full advantage of a mechanics lien, the contractor has a certain deadline by which they have to a certain deadline by which they have to take enforcement action. Now, like most things with mechanics liens, these deadlines vary from state to state, and I can't even, there's 50 different deadlines, 50 different regulations. Can't even give you all of them, but I can give you some of the examples of the states that I work in. I'm in New York, and when I worked in New York, Connecticut, and Pennsylvania. New York contractors have 1 year to enforce the lien from the date of filing. So the date that they file their mechanics lien, they have up to 1 year to actually enforce the lien, and we'll go over what that means. Connecticut has 1 year as well. So from the date you file, you get 1 year to actually enforce the lien. And Pennsylvania has a deadline of 2 years, which is pretty long compared to other states. Now, it's important to understand that the contractor doesn't have to actually foreclose on the entire lawsuit. All they have to do is start it in that window. So when I say enforce the lien, it means take action. It means to start the lawsuit, get things moving forward. They don't actually have to foreclose on the entire lien in that window. Extensions are sometimes a possibility in some states. there are states where the mechanics liens are so confusing and convoluted that like it's hard as a writer to keep them straight, because I write about all of them. But since the entire point of the seminar is to understand how long a lien lasts, we should look at how you can push the extension, because some states allow them. I love this topic because only 6 states allow extensions, but they're some of the most confusing states. So what's another layer just to confuse it even more? There are 6 states, like I said. They are Alaska, California, Florida, Idaho, New York, and Oregon. I'll start with Alaska because it's like the most straightforward, but as we continue down with those states, they get more and more confusing. So like I said, Alaska is pretty straightforward. The typical deadline for enforcing a lien is 6 months. So from the date that you actually file the lien, you have 6 months to take enforcement action. If you file an extension within those 6 months, you get an additional 6 months from the date of the extension. So you could get up to 12 months if you're able to file your extension at the last day of your original 6-month period. Probably shouldn't wait that long just in case there's an issue with paperwork. But you have to file the lien with the same office that you filed, the lien extension with the same office that you filed the original lien. That's pretty straightforward. Like you're going to double the window as long as you do it within your original 6-month window. California gets a little dicier. California's deadline for enforcing a lien is just 90 days, so it's much less than Alaska. But if the property owner, this is really, you gotta listen to this because this gets a little confusing. If the property owner and the contractor come to a credit extension agreement, they can file that extension with the same office as the original lien. So if the contractor and the customer decide that, hey, we're going to work this out, we're going to put a credit agreement together, the contractor can file that agreement with the original office, and that extends the deadline, gives them the extra 90 days. But they still only, even if they get that extra 90 days, they only have up to a year to file, to foreclose on the lien from the completion of the project. So that's very confusing. And at the end of this, I'm sure there's going to be some type of, we're going to work this out into an article so you can actually review that. But basically, within 90 days, if you come to an agreement with the customer, you can extend it an extra 90 days. That's California. Now, Florida is a whole different animal. Typically, mechanics lien in Florida lasts for a year. So you have to start your foreclosure action within 1 year from filing of the actual lien. The lien can only be extended if the contractor provides additional goods and services for the customer. So if the contractor files a lien and then continues to work with the customer, they can keep extending. But what they're actually doing is doing an amended lien, which kind of just starts the whole cycle over again. So it's very confusing, but if the contractor wants to, they can keep amending a lien indefinitely, but they're going to go broke doing that. Now, Idaho, the typical enforcement lien is 6 months, but the contractor can buy themselves an extra 6-month extension if the project owner makes a partial payment. So if I'm a customer and project owner in Idaho, I make a partial payment, you're able to extend the deadline. If I don't make a partial payment, the customer can't extend the deadline, or the contractor can't extend the deadline. So to me, it just makes sense that if you're a customer in Idaho, you don't make the partial payment. But that's, obviously that's not legal advice. That's just how it reads out. Beyond that partial payment, if there's a credit agreement established, they have the same type of rules as California, where you can put that credit agreement onto the original lien. They have some very strange terms for the way they explain it, and they're actually kind of vague. But I would assume that you just file the credit agreement with the same office where you filed the original lien. Now, New York's, this is my home state and I love it. I was just telling Lori how much I love New York, but New York's essential rules are probably the funniest. So in New York, once a contractor files a mechanics lien, they have up to 1 year to enforce it. Within that year, contractor can extend the deadline by filing an extension in the county office, for us it's the county clerk, in which the original lien was filed. So if I live in Ulster County, I file a lien in Ulster County where the project is, I can file an extension with the same county clerk. I get an extra year at that point. But if I miss that deadline, you would think that the lien would expire like it does everywhere else. but not New York. Even if I actually miss the original 1 year deadline, I can go to a court and file for an extension. And if the court approves it, I get an extra year, which is insane to me because you don't even have to watch the deadline as long as you can get the court to approve it. But that's kind of like the recurring theme with all of these extensions. They're just off the wall. So with Oregon, I don't even completely understand this. So I'll do my best to explain it, but the rules are so confusing that I don't even totally understand. Oregon's deadline for enforcement is 120 days from filing. So if you file a mechanics lien, you get 120 days. But if that mechanics lien has language that extends the deadline, then an extension is possible. What that doesn't mean is that if you file a lien, you can then file an extension. The original lien has to contain language that says that the deadline needs to be extended. So on the day that you file the lien, you have to have that into the contract. I don't know how they can make that work. I don't know. I don't have a clue about as to what that language looks like in the contract, but that's what you can do, and you can't do it after you file the lien. There's also a clause where if you come to a payment plan, the plan itself extends the deadline for up to 120 days from the last day of the payment plan that you outlined with the actual customer. So if the customer doesn't pay and you put a 6-month payment plan in place, you get the 6 months of the payment plan, and then you get 120 days from the last day of that payment plan. So the big takeaway here is that extensions are awesome, and they're not even at all confusing, except for everything that's confusing and convoluted about them.
Love it.
So that's that. We can skip to the next slide. We got it. So that's a lot of confusing information about extensions. I get that, and I go through it fast. I speak fast. That's how it goes. But the customer, I don't know if everybody knows this, and Lori alluded to it earlier, the customer can shorten the deadline. And I feel like this is a really important topic that not a lot of customers are aware of, or I don't know if a lot of contractors are aware of, but it can be a very big deal. And I've actually been writing about similar subjects recently, so I feel pretty good about that. So by now we know each state has its own deadline for enforcing a mechanics lien. And we know that some ridiculously confusing rules allow contractors in some states to file extensions. But it's also possible for the project owner to shorten the deadline by filing a notice to foreclose. This is different than a notice of intent to foreclose, which the contractor actually sends. This is something that the project owner does to cut the amount of time that the contractor has to file a mechanics lien. So if the customer is finishing their job, working with the mechanics liens, and they find out there's a mechanics lien on the property, they can send a notice of intent. Excuse me. Let me start back. If the project owner notices that there's a lien on the property, they can file a notice to foreclose, which can take a 6-month window, depending on where you are, or a 1-year window, depending on what states allow it, and cut it up to 30 days. So you can have just 30 days as a contractor to actually take action to foreclose on a lien. It's basically the customer telling you it's time to put up or shut up. So if the customer says, hey, you can foreclose on that lien, you've got to then get on your horse and get the job done. You've got to put everything together in 30 days. You've got to have all your documents, all your invoices. You've got to line up a lawyer. You've got to do everything in 30 days. Otherwise, that mechanics lien expires. But the same rules apply as before with the regular standard deadlines, is the contractor must initiate the lawsuit, not actually complete the process. So they don't have to finish foreclosing. It doesn't have to be everything in 30 days, but they've got to start the process. Now, I think a notice of foreclosure makes a lot of sense for customers or project owners to do, because it forces a contractor to take the necessary steps to start the lawsuit. If they feel like the contractor was bluffing, because that's a possibility, or if they feel like maybe the lien's not valid, or they feel like they have a really good chance of winning in court, a notice to foreclose can actually tear the lien claim to shreds, because they're telling them, all right, rubber's got to hit the road now. If you want to actually collect on this money, you better take me to court. I don't know if we're giving up the ghost by saying this, and I hate to do that because, Levelset's wonderful, but I think project owners should probably try utilizing notices of foreclosure more often. it sounds scary, but most contractors think they have until the typical deadline to get their ducks in a row. So, you know, in New York, I got to have my regular window. But if the customer is able to file a notice to foreclose, I could be, you know, sent reeling because I don't even know. I don't have my ducks in a row. I wasn't ready. I thought I was going to have a certain amount of time. Now I've got to get everything together in 30 days. If they do that and the customer isn't able to make, the contractor isn't able to make it happen, the lien expires. The problem is there's only one real way to protect yourself against a notice to foreclose. You've got to be ready to foreclose. You have to have your paperwork in a row. You got to send preliminary notices and notices of intent when they're required. Some states require preliminary notices and you have to have them sent in. You got to keep impeccable records. You have to think about your payments, your payment reminders, and maybe the most difficult of all is you've got to line up an attorney. I would think that most good attorneys would see that there was a notice to foreclose and be able to at least initiate the lawsuit in that time. But if you don't have somebody lined up, you're on your own there. You've got to file with the court. You've got to take care of everything yourself, and that could be a little overwhelming for a contractor that's busy handling projects, growing their business, and doing the best they can. So for that reason, it might be good to have a go-to construction attorney on your side. If the lien is going to expire, there's only a few ways that actually it can go. The contractor gets paid. The customer pays them. They get their money. They release the lien. Contractor can't or doesn't foreclose in time. We know that that's a possibility because if it's only 30 days and they can't get their stuff together, they could actually just run out of time and not be able to get the foreclosure process done. The lien could just expire. So if it's a year and they go a year and they don't get the foreclosure in place, it can expire. They go to court and the court decides the outcome, regardless of whether it's for the customer or for the contractor. Or the lien can be found to be invalid. And there's several ways that could happen. If they don't send preliminary notice, if they sent it late, if they aren't foreclosing in time, there could be a number of things that make the lien invalid. So regardless of what happens, the lien may require, it depends on the state, but may require a formal release to truly disappear from the property record. So the contractor who filed the lien actually has to file a formal release. When it's forced to in these states that require it, there's two ways it can be done. The deadline from when the lien is actually satisfied and a deadline from when the date of a written demand is received. So some states require the contractor, they have a certain amount of time after the lien is satisfied, whether through the court or from the customer paying them, while other states require a written demand letter, and they have a certain amount of time from the time that is received to actually go to the county clerk's office and have the lien released. So between these two outcomes, lien satisfaction isn't very scary. Obviously, you're going to get paid. That's what the whole thing is about. That's not so terrifying. If you get paid, you should release the lien. All you need to do is head down to the office that you actually filed it with. So like I said, for New York, it's a county clerk, and it's usually the county clerk in most of the other states, and complete the proper paperwork. But written demands can be a little bit more unnerving. Some states hold contractors liable with penalties and fines if they don't release the lien by a certain deadline. A well-written demand letter from somebody who really knows how to write one can sound pretty scary. They could be demanding that they remove the lien before the actual deadline even passes. And if they make that sound scary enough, some contractors will actually give up their rights prematurely. And that could allow the project owner could give them the upper hand. If they owe the money and they force the contractor to release the lien early, the contractor has really no recourse. They could try a regular civil lawsuit, but that's so expensive and long drawn out that may not be worth it depending on the amount of money. What can also happen, and this is pretty common, and contractors need to be aware and actually put this together. Beyond the actual demands and satisfactions and deadlines, contractors can be lured into releasing their liens for promises of a payment from a project owner. But you can't cash a promise at the bank. You know, you can bring a bag full of promises there and they're not going to give you a dime. Contractors need to remember that they're running a business and that they have a document that promises payment. They've had it the whole time. There's a document that says that they're going to get paid and promises that, and that's the original contract. If the contract if the contractor has to file a lien to get paid, then obviously the legally binding document that promised them money wasn't even enough. So why accept a sob story or a promise for anything other than what it is? Releasing a lien before receiving a payment is a bad idea for the contractor, because all that customer has to do is say, hey, I'm going to pay you, release the lien. You do that, and next thing you know, they walk away scot-free. They don't have to pay for any of the materials or any of that, as long as they get it outside the deadline. So how can you reduce the risk of having a lien released without payment? Any contractor who releases their lien before they're actually getting paid is just, they're undermining the actual value of the lien. The lien needs to stand over the customer until they get paid. And they can do that even with a payment plan in place. So as long as they have the agreement, it shouldn't bother the customer that there's a lien on the property. The best way to protect yourself from having to release a lien is to keep your ducks in a row on all of your projects. A project owner can't force you to release a lien if you're meeting all of the requirements set forth by the state. So that means making sure that you meet your notice requirements between notices of intent, preliminary notices, making sure that you're watching the important deadlines like getting your mechanics lien filed in time, and making sure that you keep impeccable records. You want to have all those invoices, you want to have license documents, you want to have insurance documents, anything that a customer can do in court to try to make you look bad, you want to make sure you have squared away. Once you have all that, and like I said, a good construction lawyer on your side, you don't have to release that lien early. It doesn't matter if there's a demand to release it, letter mailed to you, as long as you're within that deadline, you haven't been paid, you don't have to release the deadline. And contractors need to understand that. To release it early without being paid, it just undermines everything that they've done.
Great news is there's been a lot of communication going back and forth between the chat and the Q&As. So This is a lot of new information for people, and it's definitely well received. I do have several questions. First one is from Chad. It says, how does someone go about making a lien invalid?
So he wants to make a lien invalid?
Yeah, so it's probably maybe from the property owner's side where you said that they could reduce the time.
Well, so my go-to canned answer is always like, if you have a question about something like that, find a construction attorney. But what they should do is they should get to know the actual rules and regulations in their state, or the state of which the project was actually held. It doesn't matter if it's in another state, you have to go with that other state. They should check to make sure that the contractor met all the preliminary notice requirements, notice of intent to lien, make sure that they hit all the deadlines that they were supposed to hit. If they miss those, the lien, whether or not it was valid or not, or whether they were getting paid, could be invalid. And there are states where it's like a sliding scale. So if you are late on your notice, it's not that your whole lien is invalid, but that the amount from before you sent the lien, from the date, that part of the money is not protected. So if a customer feels like they got the preliminary notice late, or that the lien was filed late, and it's for the whole amount, at least some of that actual lien is going to be invalid. At least some of the amount.
There's a lot of different things, it sounds like, that can go into that.
Absolutely. That's why a construction attorney is probably best.
No problem. I got a question from Aaron. Do liens affect the person's credit?
Okay, so this is a good one. Yes and no. That's like always the answer everybody hates to get. Yes and no. It can show up on a credit report. It doesn't always. I believe there's some rules with Experian. I'm not sure what the actual rules are, but what can show up is if the contractor is successful in foreclosing on the lien, and they have to get paid for their money, and they sell off whatever the lien claim is to a collection agency. If that collection agency then goes ahead and closes and comes after you, that'll show up on your credit report. So the lien itself may or may not, but if you don't pay the actual lien amount after a successful foreclosure, that'll show up on the credit. That'll be a big problem.
Perfect.
So yes and no, like I said.
That's on everything.
Yeah.
Mary says, you said some liens expire within 90 days, whatever state that was. So do you have to file for foreclosure basically when you file the lien?
So no, you have the 90 days to file for foreclosure. The problem is if you wait till the 90th day to start your lawsuit process, you're going to be outside of that deadline without a doubt. Something's going to happen where you don't have the right paperwork, or the court closes the second you get there because somebody went home sick. So you can't wait the 90 days. You can wait within that window, but it's best to get that stuff squared away the earliest as possible.
Thank you. John says, I have never heard of a property owner being able to shorten a lien. How would property owners know that they could do that? And if so, I guess when they do what they're going to file, do the supplier or whoever filed the lien get notified?
Okay. So not all states can do a notice to foreclose. Not customers in every state can do that. Only certain states can. I'm not sure which they are.
Okay.
I'll look that up and I'll let you know. But they'll have to check what the regulations within their state. I imagine that the regulations will be statewide, so they can figure it out from there. But what they will have to do is they will have to notify the contractor of the notice to foreclose. So the contractor doesn't have to worry about not finding out and then the window closing. They have to be notified. If they're not, I imagine that the original window would still stand. So even if they file that document and they don't get it out to the contractor, the original window would still stand. That would be up to the court, but that's the way that would probably work out.
Let's see. Sam says, are there any demand letters that you can send to collect on a lien once it's filed?
Okay, that's a pretty common question. So demand letters are great because they let somebody know you're expecting money, right? Like that's great. But what they don't do, they're not standardized, and they don't really have any teeth. They don't have any bite. They're not legally binding documents. They're just, hey, you owe me money, you got to pay me. What they should send instead is a notice of intent to foreclose. We have them and we offer them as a service through Levelset, and that's a legally binding document. Some states require them. So it's kind of for whatever reason I love nautical nautical themes. So what I like to say is it's like a shot across the bow. So it's like that last warning shot before the battle actually starts. So if you send a notice of intent to foreclose, they know that you're serious. They know that you know what the rules are. In some states, it's a regulation and a requirement that you have to meet. And then once you do that, that's when they know, hey, the next step is we're going to battle, which in this case is foreclosure.
I think that would look scarier than a demand anyways.
Absolutely. Yeah, it's a more official document when it comes, with letterhead on it, and it looks like the right requirements, and they're talking about foreclosing. It's way scarier than just, hey, you got to pay me.
They're probably used to those.
Yeah. You've been sending them for probably months at that point anyway.
Right. Dawn says, only 6 states allow extensions. Do you know how someone could get their state to follow the laws of the other 6 states?
Well, I don't know. I don't know how to force a state to do what you want them to do, because that's kind of if I could figure that out, I'd be much better off. I would say the best case, if you consider that New York, you can actually miss the deadline and still try to go through a court to get an extension. I would say that the best case, if that's the scenario, is to get a construction attorney and see what they say. Chances are it's not going to be the first lien deadline that they've got to try to hit. So I'm sure that they know what to do, and they probably spaced it before. But I guess it could be possible, especially if you consider New York's requirements.
Thank you. I got a new question that just came in from Jason. Is an intent to lien different than an intent to foreclose?
So a notice of intent to lien and a notice of intent to foreclose.
Correct.
So the notice of intent to lien, if I'm understanding this correctly, is that you're going to file a lien on the property. So you're letting them know that, hey, if they don't pay you, you're going to file a lien. Notice of intent to foreclose is letting them know, hey, like their lien is here, I'm going to foreclose. As far as I know, the notice of intent to lien is the state. Some states have a requirement that requires a notice of intent to lien. I'm not sure if they have how many states have a notice of intent to foreclose, but notice of intent to lien are different.
Thank you. I got Michael asking, oops, hold on, it just went away. Is your right to extend based on the state where you're based or where the job is based?
I love that question. So it's easy. This is not a yes or no question. It is going to be based on the location of the project. So if I was working in Connecticut, I actually had to learn Connecticut rules. So if wherever that project is, it's that local government's laws that actually govern whatever the mechanics lien laws are there. So you have to meet the other areas requirements. It doesn't matter where your office is, doesn't matter where you live, only where the project is.
I know that can be a tricky one for people that operate in different states.
Yep. Well, so I live in the Hudson Valley, and they've got 2 states within 45 minutes of me. So it could be very confusing.
Adam asks, if a lien is filed and then satisfied, how long does a contractor have to remove the lien from the title?
Okay. Sure. So it depends. If it's satisfied, it depends on how it's satisfied. If it's satisfied through court, sometimes the court will take care of the lien. But if not, it's going to depend on what their state laws are. And even if the lien is satisfied, the customer may still have to file a written request to have it removed. If not, they don't really have a deadline that they have to work with.
Perfect. This one came through anonymous. It says, what is the difference between prelim and lien?
Okay, so preliminary notice is, I love this because I write this all the time. I can give you my whole spiel. The preliminary notice is like a friendly introduction between your customer and your company. So I like to say that it lets the people who are cutting the checks know who you are, which is great. But at the same time, it also meets the requirements many states have to protect your lien rights. So if you don't send a preliminary notice within the certain deadline, depending on whatever state it is, you may not have lien rights. What were they comparing it to? The lien?
To a lien, yes.
Okay, so the lien is a claim against the property for unpaid services, supplies, or labor. So what that is basically you're saying, hey, you didn't pay me. I put a lien on your property. If you don't pay me, I can potentially force the sale of your property and take my proceeds out of that. So the preliminary notice is a lot friendlier, and it's a requirement before you actually get to the lien itself.
Perfect. Michael also asks, do you know anything about liens in Canada?
So I don't. I do know that a lot of the language doesn't translate exactly the same. So there are notices in Canada that have a lot of weight. They can actually shut a job down. Whereas in the US, most of them don't do that. So all I know is that there's a difference. I'm not really all that well versed on Canadian mechanics lien law yet, but it's something I'm looking to get into at least. Seems pretty interesting.
Yeah. I've seen a lot of stuff coming up about that, but yeah, I'm not familiar with it either yet. Something we'll definitely have to look into. I got another question from Adam. Well, he's asking what states require a preliminary notice, but I could actually help you with that after the webinar. We have a whole list of different states that require different things, and I can get that over to you. Yeah, Jason says our customers get so confused on the prelims and they think it's a scary thing.
Well, I think that a lot of people use the language pre-lien, and that does sound scary. I mean, I think we actually have an article of why maybe not to call it a pre-lien, if I remember correctly. A pre-lien does sound scary, but a preliminary notice is a lot friendlier.
And I think that's the last question. Nobody's popping one through there. Tom, thank you for this. Like I said, I know that this was a lot of great information, a lot of stuff that some people probably hadn't heard before. And, you know, it's definitely something that I was interested in. And hopefully we can get you on here with some more information or even about Canada someday.
Hey, there you go. Well, thank you for having me. I appreciate it. I hope it wasn't too dry. I know it's kind of I like the topic personally, but, you know, I know it can come across a little dry. It's a lot of information.
It is, but I think anybody dealing with liens kind of knows where you're going with it. So, you know, it's not as bad as accounting figures and stuff like that.
That's not for me.
If anybody wants any additional information, we do offer a class by Thea Dudley. It's in our Credit Management Academy Center. And she actually goes into a lot of basics, but she also talks about liens and the different things you can do and not do, and the prelims as opposed to the liens and all of that sort of stuff. So I will go ahead and put that link in the chat box. And then she also has a book out there. I'll put the link as well. If you actually go to that link, you can download the first 11 pages for free. And if it interests you, just shoot me an email and I can get you a copy of that book as well. Hold on. Looks like somebody might be. Oh, no, they're just letting you know that law is dry in general, so they understand. Well, thank you again, Tom, for joining us. And thank you, everybody else, for joining us as well. And I hope you have a great evening.